The hearing will start now. Originating application 383 of 2022, Zipmex Asia Pte Ltd.
All right. Good afternoon, Mr. Jonathan Tang, for the applicants and various persons in attendance. All right, Mr. Tang, we have a number of applications this afternoon. Let's proceed with the sealing application first.
Yes, Your Honor. The application for sealing is summons 4504 of 2022, supported by the 17th affidavit of Marcus Lim, which was filed on the same day as the sealing application, Your Honor.
Yes.
There are a few developments in terms of correspondence with the courts. Yesterday, we received a letter directing us to make available the 17th affidavit and the summons to creditors. We have written back to the court to clarify these directions, and we received another correspondence this morning. Your Honor, because of the forum and the probability that this hearing will be on YouTube, I'm not at liberty to say so much about the reasons for the sealing, but
No, you need to do so, Mr. Tang. You need to do so. You need to justify it right now in this hearing. If you're not going to do so, I will not grant the sealing.
Yes, Your Honor. Well noted. Well, Your Honor, the reason for the sealing application is a clerical error on our part when it came to the filing of the 14th affidavit of Marcus Lim, right? When we discovered the inadvertent clerical error, we immediately filed the sealing application. And we would also request that the two letters we had written to the court, dated 22nd and 23rd December, as well as the text of the 17th affidavit, be also correspondingly sealed pursuant to summons 4504 of 2022.
All right. So you require redaction of the two letters you send into the, or rather sealing of the two letters you send into the court, as well as addressing the inadvertent disclosure in the 14th affidavit, correct?
Yes, Your Honor.
All right. So in brief, what is the reason for the sealing again?
Inadvertent clerical error.
No. What is the basis?
The basis is as set out in the 13th affidavit for the reasons set out therein, which Your Honor had granted.
State the reasons, Mr. Tang.
Yes, Your Honor. Commercial confidentiality, including the identities of the investor, as well as, well, actually, no, that's it, Your Honor. Commercial sensitivities concerning the identity of the investor, as well as the details of the transaction as a whole.
All right, can I have an assurance at this point that the identity of the investor will not prejudice the interests of the creditors in any way?
Yes, Your Honor.
And it's solely for the commercial, because of the commercial impact of the knowledge of the identity is made known, correct?
Yes, Your Honor.
All right. All right. Unless anything arises, I will grant the sealing application accordingly. So this is 4504, correct?
Yes, Your Honor. That's at tab 3 of the bundle of documents, if Your Honor wishes to reference it.
We need to make some amendments, correct?
Yes.
So do you have
No, Your Honor, I don't have proposed draft language readily available, but I can propose amendments to prayer 1, if the court so pleases.
Yes.
That the 14th affidavit of Lim Wei Siong Marcus, and Your Honor, I'm reading from prayer 1, filed on 16 December 2022 in HC Sum 4450-2022, comma, the 17th affidavit of Lim Wei Siong Marcus, filed on 20th December 2022,
Mhm.
in HC Sum 4504 of 2022,
Mhm.
comma, and the letters from Mrs. Morgan Lewis Stamford LLC
Mhm.
to the registry dated 22nd December 2022 and 23rd December 2022 be sealed and not be open for inspection until further order of this honorable court.
All right.
With the remaining prayers to stay, Your Honor.
All right. Order in terms prayer 1 is amended, and prayers 2 and 3 as well. Thank you. All right, let's proceed to the summons proper.
Yes, Your Honor. Before we go forward to the summons, I need to draw the court's attention to two other housekeeping matters.
Yes, all right.
The first is that late yesterday evening, Your Honor, we had filed an 18th affidavit.
Mhm.
The 18th affidavit, I believe, has been made available to creditors through an announcement. I don't have full control over this because it's by the company, right?
Mhm.
But we did request that the company make such an announcement.
Mhm.
The 18th affidavit, Your Honor, sets out relevant materials and agreements for the court's perusal and the creditor's reference. This
Mm.
includes the entry into an amendment agreement for the SSA, as well as the entry into a super priority financing agreement and updates on the receipt of funds and the entry into a share purchase agreement for one of the company subsidiaries.
Mm.
So that's the first matter.
Mm.
The second matter is minor amendments to be made to the prayers in summons 4450. Your Honor has seen that there was an annexure to the 16th affidavit of Marcus Lim that was filed on the 16th of December. For ease of reference, I've also reproduced this in the written submissions before, Your Honor.
All right.
In
What do
Annex
you deal with the amendments when we get to them?
Yes, Your Honor.
What, at this point, could you summarize your position, please?
Yes, Your Honor. In essence, the application is a multi-tiered application under Section 67(1) of the Insolvency Restructuring and Dissolution Act for super priority to be granted over various tranches of loans to be disbursed prior to completion of the eventual investment by the investor. Just to give creditors and the court a flavor of what these loans to be disbursed are, they are loans that will be disbursed in December, January, and February 2023, right? The completion is expected to take place on or around end March 2023. The moratorium ends 2nd April 2023, and we hope to have the distribution or the access to customers' crypto assets to be activated on or around early April 2023, right? These loans are, as set out in the submissions,
Yes.
for the purposes, for various purposes, Your Honor. Your Honor can see that in the tranche 1 loan, it is a sum of USD 1540757, right? 1.1 million of this is to be applied towards the capitalization of Zipmex Indonesia. The remainder is for working capital. Your Honor, I'm just trying to find in my submissions the table for ease of reference. So if you look at paragraph 7 of my written submissions, Your Honor, I think maybe this will better assist, because then there's a table there that sets out visually what I'm about to say.
All right. Mhm.
Your Honor, if I may.
Yes.
So at paragraph 7, I have set out a table there which shows the court and creditors as well that tranche 1 is to be received by 6 December 2022. This sum USD 1540757, like I mentioned earlier, 1.1 million will be applied towards capitalization of Zipmex Indonesia to comply with requirements that I believe will be implemented by prohibited in the near future. These requirements that I'm referring to, Your Honor, are an increase mandated by the regulator for crypto exchanges operating in Indonesia. The minimum capitalization will and should be increased from 50 billion IDR to 100 billion IDR. So part of the tranche 1 sum has been set aside for this increased capitalization. For tranche 2, Your Honor, is a sum of USD 1809243. Of this sum, 1 million will be the refund of will be applied towards the refund of a deposit paid by a potential lender that came about through the MOU process that was set out and described in Marcus Lim's third affidavit when this first came before the court back in July, right? The remaining 800,000, give or take, from this figure is set aside for working capital. Flipping the page, Your Honor, you'll see that there's a description of tranche 3 and tranche 4.
Right.
Tranche 3 is a sum of 1250000. This is to be applied to working capital. And this is broadly commensurate with the group's projected burn rate moving forward from December onwards. The group projects that it will burn around 1.2 million USD per month, right? So these tranche payments are staggered to help it meet its burn rate and projected expenses. The same goes for tranche 4, Your Honor.
Right.
So taken in totality, the sum to be secured and what we term the super priority amount is a total sum of 5,850,000 USD 5.85 million.
Yes. All right.
The primary relief we seek in this application is for this sum to be secured by the grant of the creation of charges over shares owned by the company. The shares are the company's ownership of Zipmex Thailand, Zipmex Company Limited, right? As well as Zipmex Indonesia, which is PT Zipmex Exchange Indonesia. Your Honor would have seen in the affidavit that the indicative value based on a valuation done by Corda Menta on the low end is about USD 6 million, right? So it covers the total sum of the super priority amount. And this is only the security to be granted by the company. And which is relevant to the application today. So this is the first tier of super priority status that we are seeking. The investor has also made a request to the company that any unrealizable amount from the super priority loans be granted super priority status under either Section 67(1)(b) or Section 67(1)(a) of the Act. And this informs prayers, and Your Honor, if I could trouble the court to refer to the amended summons without notice, just so that we are all on the same page here. So this is at the end of my written submissions as an annexure. This informs prayers 1B and 1C, the prayers in alternative for unrealized balance to be granted super priority status under these two provisions of the Act. So to sum up, Your Honor, the primary relief is for super priority status to be granted over the security under 67(1)(c)(1) of the Act, or the unrealized balance to be granted super priority status under 67(1)(b), or alternatively, for the unrealized balance to be granted super priority status under Section 67(1)(a) of the Act.
All right.
That's the primary relief, Your Honor. There's also secondary relief, and would the court wish for us to get to elaborate in detail a little bit further
Those
on?
are parts 2 and 3, I think.
Yes, Your Honor.
I'm not entirely sure whether they'll be required. Perhaps at this point, you could just go into your satisfaction of the legal requirements.
Yes, Your Honor. Well, the legal requirements are very helpfully, or have been very helpfully enunciated by Your Honor in the judgment of Redesign Studio, which I had made reference to in the submissions. And Your Honor had identified in that particular case the 3 mandatory requirements and the 4 so-called discretionary requirements. And if the court will grant me the indulgence, I wish to proceed to show exactly how the company has satisfied all of these requirements.
All right.
Yes, Your Honor. Well, the first mandatory requirement, and perhaps at this point, we can once again turn, Your Honor, to paragraph 25 of the written submissions.
Yes.
And I've taken the liberty at paragraph 25, page 15, to sum up Your Honor's observations in Redesign Studio. So the first mandatory requirement is that application must have been made for a scheme meeting or moratorium under section 64(1) of the IRDA. Your Honor, the company has satisfied that. This is OA 383 of 2022, which was an application under 64(1). The second requirement is that the proposed financing must constitute rescue financing under section 67(9) of the IRDA. The definition of rescue financing, Your Honor, is set out as the second mandatory requirement mentions 67(9) of the IRDA. That is tab 1 of the bundle of authorities. And is defined very broadly as follows. Rescue financing means any financing that satisfies either of the following conditions. The first is that it be necessary for the survival of a company that obtains the financing, all of the whole of any part of the undertaking of that company as a going concern. The second alternative reading of rescue financing is that the financing is necessary to achieve a more advantageous realization of the assets of a company that obtains the financing than on a winding up of the company. Your Honor, turning to section 67(9)(a), we say that the super priority amount that we have broken down earlier does in fact satisfy particularly section 67(9)(a), simply because this is financing that is necessary to ensure that the company and its subsidiaries, being the other applicants who run the crypto exchanges in the group restructuring before Your Honor, have the necessary financing to continue their operations throughout the course of the moratorium. Your Honor would have seen in the affidavits that the group currently has about a USD 700K bank balance in cash, right? The projected burn rate is 1.2 million. At this point in time, the group or the company anticipates that if the rescue financing is not in through the tranche mechanism before the end of the month, then it can probably only survive until mid-January next year. And this is because in addition to employee salaries and marketing costs required to run all these crypto exchanges, there's also the small matter of vendor payments. And these are critical vendors such as Amazon Web Services and Alpha Point that service the platforms and that allow the platforms to continue going. The alternative, Your Honor, if the tranche payments are not extended to the company, are that these crypto exchanges can no longer continue operating, probably by mid of January next year. And given that, the next logical step, Your Honor, will be liquidation in each of the jurisdictions. So when it comes to whether the financing is necessary for the survival of a company that obtains the financing as a going concern, we say yes. This bar has been satisfied. Alternatively, Your Honor, for the second limb of section 67(9), we would also say that the financing and the overall transaction contemplated by the SSA would definitely achieve a more advantageous realization of the company's assets than on a winding up, simply because this is the route to the restructuring. This is the plan for the restructuring, as Your Honor would have seen. And so this is the overall transaction contemplated will be the one that allows creditors, both vendor and customer creditors, to obtain 100% realization of both the vendor debts as well as the assets that are presently withheld by the company in the Z wallets. So in relation to the fulfillment of the conditions under section 67(9), we say yes, the company's application and the super priority amount does satisfy this condition. Your Honor, regarding the third requirement, the company would not have been able to obtain the rescue financing unless the debt arising from the rescue financing is given the priority mentioned in the provision. In this case, looking at the primary relief, the provision is section 67(1)(c)(1), right? How this has been interpreted, Your Honor, by Your Honor and Atilan, and as well as the cases that have subsequently followed, is that we need to show reasonable efforts. We need to have conducted a comprehensive outreach, but such outreach does not need to be exhaustive, right? And this can be seen through, Your Honor. And here I am going to bring the court to paragraphs 54 onwards of the written submissions. Or actually, maybe, Your Honor, if I could turn the court to paragraph 55, there's a table there which we can refer to. So just to summarize the outreach, and what I term outreach, but rather the efforts of the company and its appointed financial advisor, Corda Menta, to obtain alternative financing. Your Honor will recall that back in July, the company was already in the news for potentially being a distressed asset, right? When we attended the hearing before the court in August, and this was supplemented by the third affidavit of Marcus Lim filed before that hearing, we had identified 3 potential investors who had given MOUs or analogous documents to the company to show their interest in an investment, right? So this sets the stage, Your Honor. We already know, and the public already knew, that Zipmex was potentially an asset that needed outside investment. This becomes relevant when we look at later outreach. In September, Your Honor, what we term the 8th September 2022 outreach, Your Honor would have seen that Corda Menta, as well as the company, had sent exploratory emails to 10 potential lenders, right? Sorry, Your Honor, my apologies. This was Corda Menta only in September 2022. Your Honor, there is a customer who had made a chat. It just came up.
Address it first, please. Just carry on with the submissions.
Yes, Your Honor. So I was at the 14th September outreach, which is what I defined in the submissions. This was directed to 10 potential lenders by Corda Menta, right? The response came back very cold. Basically, in short, nobody was interested, right, to make an investment into the company. Subsequently, Your Honor, there was further pursuit and negotiations between the company and this particular investor, which eventually led to the SSA. In the course of these negotiations, there were preliminary terms of investment, and this is set out at page 29 of the submissions, where we had reproduced the email that the company and Corda Menta had sent to potential lenders on 8 November. Right. This table sets out what the terms of the SSA were at that particular point in time. And Your Honor would have seen that we had asked potential lenders, Corda Menta and the company had asked potential lenders at that time to extend the same terms of financing as what was then contemplated to the company. In total, they had reached out to 16 parties. These 16 parties comprise a mix of banks, crypto exchanges, funds, crypto VCs, and strategic investors. Of the 16 contacted, 6 had come back to say they were not interested. 10 did not respond. There was a last round of outreach, and the last round of outreach was on 5th and 6th December 2022. This was following the extension of the moratorium and the entry into the SSA on 30th November. So by that time, Your Honor, the super priority amount had been crystallized and is the amount that is now before the court in summons 4450. So this last email was sent to 14 potential lenders to ask them if they were willing to lend on the terms that we are now seeking in this super priority application, including the grant of security in exactly the same terms as that which we are seeking here. There has been one response received so far, and the response was in the negative out of the 14. We haven't received any responses from the other 13 that I am aware of. I think it is important for me as well to compare this to previous cases, Your Honor. And this is at paragraph 58 of my written submissions. I can leave Ethylene alone, right? But in Asia Travel, there was an outreach to 11 potential lenders. In Redesign Studio, I was not involved, but I do believe and I recall that there were 10. But that's not exactly stated in the judgment, Your Honor. In No Signboard Holdings, we had reached out to 8 potential lenders, spanning banks, alternative lenders, investment funds, and shareholders. Right, No Signboard Holdings was decided earlier this year, Your Honor. And I guess the point of me making this comparison, Your Honor, is to show that the breadth of our outreach actually does compare favorably to previous cases in which super priority for rescue financing had been granted. And it is on this basis that we say that the efforts that have been made by the company are reasonable. They are not exhaustive, but we have done sufficiently enough to prove on a balance that it is highly likely that there are no alternative or better financing options available to the company at this point in time. Your Honor, if I may go on to address the discretionary requirements.
Yes.
Yes. Your Honor had identified 4 discretionary requirements. The first, as at paragraph 31 of Your Honor's decision in Redesign Studio, was whether creditors' interest will be prejudiced from the arrangement or whether the arrangement will be beneficial to them. In respect of this particular category, I just would like to identify what I believe the prejudice may be, and then to speak about the benefit to the creditors, Your Honor. So in respect of this, the prejudice is, of course, that on a liquidation of the company, the security would then be realized, right, to pay back the investor the sum of the super priority amount. In terms of benefit to the creditors, Your Honor, I believe there are many more that will eventually outweigh this particular risk to prejudice to the creditor's interest. The first is that obviously this is money that the company would not have had but for the bargain struck in the SSA for the lending of working capital and capital to comply with regulatory requirements to the company in the interim pending completion. Right. The second matter which I would probably raise is that this security is meant for working capital, as I mentioned earlier. And if these loans are meant for working capital, as I mentioned earlier. And without the disbursement of these loans to the company, it is likely that the crypto exchanges would have to stop or cease operations. Cordamenta has commissioned a liquidation scenario for the company. It anticipates a 13% to 29.74% return on each debt. In addition to this, creditors' assets in terms of digital currency would probably have to be liquidated and then distributed pari passu. There will potentially be a long delay to finalize the liquidation given the complexity of such assets and the difficulties involved in selling both crypto assets as well as crypto subsidiaries. On the other hand, Your Honor, if the restructuring succeeds, customer creditors will obtain full access to 100% of the amounts that are held in their wallets, the Z wallets. Vendor creditors will receive 100% repayment on completion or shortly after completion of the total investment contemplated by the SSA. It is our submission that in this particular case, the risk is greatly outweighed by the benefit of allowing the super priority application to proceed and for the investment to complete, because a super priority application is a fundamental tenet of the disbursement of loans and the completion of the SSA. We would go so far as to say that this is in the creditor's best interest, because without the additional funding, the scheme would not be viable, and the creditors will not have much to look forward to except a liquidation of all of the 5 entities. Your Honor, if I may. Yes.
That is
So
all. Mhm.
that
Yes,
deals
Kira.
with, that deals with the first discretionary requirement.
Mhm.
The second discretionary requirement that Your Honor identified was the viability of the restructuring.
Mhm.
This was submitted in more detail or at the 2nd December hearing before the court. So I don't propose to go over old ground, Your Honor. But just to reiterate that this is a scheme of arrangement or group restructuring that contemplates 100% return to creditors, both customer and vendor creditors of each of the companies.
Mhm.
And I think I can add on to what was previously said at the 2nd December hearing by showing the commitment of the investor towards fulfilling its end of the SSA bargain. And to that, I would highlight that the investor seems to be serious about this investment, right? There is no indication that the investor does not intend to honor its obligations under the SSA. The investor has even executed a super priority financing agreement, the draft of which was before the court at the extension hearing and which was executed yesterday. It's set out in the 18th affidavit. This crystallizes the obligations under the super priority financing. It isolates and crystallizes it. And that's why we thought, it would be useful to have that document to govern the obligations between the parties simply in respect of the super priority financing. The investor has agreed and both parties have executed that document. In addition, I should also highlight that as compared to other cases whereby investors may have been a little bit more cautious, in this case, the investor doesn't seem to have much compunction about extending these amounts, right? There's been no requirement to create segregated bank accounts. There's no requirement to appoint directors with signatories on bank accounts. There's no requirement for an escrow. And what I am raising this to show, Your Honor, is that this evidences a level of trust, right, between the investor and the company that bodes very well, we say, for the restructuring or the success of the restructuring of the group going forward. The final observation I wish to make on this particular category is that the parameters of the usage for the super priority amount are very strictly regulated. They are set out in the supplemental agreement and governed by section or clause 3.4 of the SSA, Your Honor. This means that the amounts can only be used for the purposes that are identified in the SSA as amended, right? There is little to no risk as of the adverse consequences of wantonly spending this money that Your Honor had identified in Redesign Studio. So there's no risk of risky investments or misuse of funds. Your Honor, if I may proceed.
Yes.
Yes. The third requirement, which I had dealt with earlier at this hearing, was the availability of alternative financing proposals. I don't propose to go through that again. And the last one is whether the last discretionary requirement is whether the SSA was or can be deemed to be reasonable and in exercise of good business judgment, Your Honor, just to paraphrase your requirement in Redesign Studio. following the UKSC decision, Your Honor, of BTI 2014, the one that came out earlier this year, and directors' duties to creditors, I think it is safe to say that directors of companies, including our client, have been advised that, you know, in an insolvency situation, creditors' interests ought to be paramount and foremost in their consideration. It is in this particular case, we say that the SSA transaction as a whole and the investment as a whole is very strongly in the creditor's interest, right? And the board has taken that very, very heavily into account in negotiating and eventually entering into the SSA. This has also been evidenced by the board resolutions that have been passed in respect of each facet of the transaction. That is exhibited at the final exhibit of the redacted affidavit contained at tab 4 of the bundle of documents. In other words, Your Honor, we exhibited a board resolution whereby the transaction is detailed and the board has approved each of these particular facets of the SSA transaction. In summary, we say that the SSA or the entry into the SSA is a reasonable decision. It's in the creditor's interest, in stakeholders' interest, and it will assist towards the eventual successful restructuring of the Zipmex group. Your Honor, those deal with the 7 categories that Your Honor had identified in Redesign Studio.
Yes.
Unless there's anything further from
And
the court.
you had referred to, was it, if I not know about, was it Asia Travel or Swee Hong in relation to the fact that super priority is available even for previously dispersed financing?
Yes, Your Honor. I had referred to that. Unfortunately, Swee Hong is not well, the decision in Swee Hong is not available, right? But from publicly reported sources, we can see that in Swee Hong, at least super priority was granted to debt that had already been extended to the company. And is in this case, we thought it was relevant because by the time of this application, especially when the application was drafted, by the time this came up for hearing, we anticipated that either tranche 1 or either tranche 1 or tranche 1 and 2 would already have been dispersed to the company. It turns out that in this case, tranche 1 has already been dispersed, tranche 2 will be coming within the week. And so we thought that citing Swee Hong just for that particular proposition would be relevant.
Okay. All right. Let me see. All right. Thank you. All right. Now, let me turn to the question raised by one of the creditors in the webinar chat. All right. So I appreciate it's a Thai customer asking about the email sent out on 16 December in relation to the scheme of arrangement. All right. Hold on, sorry, there's another one. Hold on. And that this will result in asking for waiver and result in exclusion from the scheme of arrangement. And let me see, there's another question. All right. Also, in relation to that agreement and the absence of any Thai translation, and not everyone has been invited, and there's some confusion about this. All right. And sorry, and they're not, and complain that they asking for a request for Zipmex to provide a clear and easy to understand explanation. All right, thank you. All right, I'm just summarizing what has been raised. So for all of you, just to recap. So today is the application is for super priority financing. What that means is that they are asking the court to allow the investor to step ahead of all the creditors in respect of the money that the investor is putting in. So their 5.8 million will be put ahead of everyone else's claims. So in the worst case, for example, if the company is liquidated or can't carry on the business, the investor will be able to look to the shares held by Zipmex Company Limited in the subsidiaries, and also if I grant some of the other orders from other assets of the company, especially in liquidation. So that basically means the investor will be put in a better position than all the other creditors. That's the point of the application today. Singapore law allows that to happen if they meet certain criteria, including the fact that it benefits, essentially that it benefits the company, that is otherwise reasonable, and that basically if it is actually necessary to keep the company going. So I'm simplifying things a bit, but Singapore law allows the investor to step ahead of all the other creditors with its new money if there's some benefit from that new money coming in. So simplifying that is what we allow, and we have allowed it in other cases in the past. So that is what the application today is about. The investor wants to be able to get some benefit ahead of the other creditors by putting it in return for putting its money to allow the company to carry on. And the benefit that the investor gets is basically that if the company is liquidated, it will get its own money back first, or even before liquidation, the investor can look to the shares held by Zipmex company in its subsidiaries. All right, so we allow that. I emphasize if certain factors are met, including that there was a good faith attempt to get financing in other ways, and if the financing is actually necessary, and if the financing doesn't unduly prejudice everyone else. All right, so Mr. Tang is making arguments to show that all these requirements have been met. So that is the point of today's application. There is a second smaller part of it in relation to the affidavits, which the company wants to be sealed so that no one else can look at it. And the primary reason for this is to protect the confidentiality and commercial sensitivity of the investment, particularly the identity of the investor. All right. So I don't think anyone has any issues about those. We do sometimes grant these orders so that investors who come in are assured that they will be not prejudiced in the commercial markets by people knowing what their plans are exactly. All right. So that is what today's application is about. Now, I appreciate that the two questions put up to me are very important to all of you, but they relate to actually what went on in the last hearing. So just to recap what happened on the 2nd of December, there's an application firstly for extension of the moratorium, which is the order of the court prohibiting people from taking action against the companies. So that was extended. The company also tried to get me to basically bless or approve the plan to get this approval of a waiver by all of you without an actual meeting. So just to go into a short description, Singapore restructurings are done in two main ways. One is by way of an actual meeting where everyone is brought together and everyone votes. The other way is what is called a prepackaged arrangement, where we don't have a meeting, but when they come to the court, the company just has to show me that approval would have been obtained, or is basically to be taken as given in the circumstances. Now, the company is trying to go by the second method without an actual meeting. What they've also tried to argue for is that we should follow the approach taken in the United States, where small value account holders don't actually have to have their approval expressly obtained. Basically, the court treats the situation as one where small value creditors, their approval is taken as given. All right. So I declined to order that on the 2nd of December. I said I don't have the ability to do so at this time, but I didn't rule out the possibility that the company can make these arguments when it comes back. What was the date given, Mr. Tang?
Before the 2nd of April.
All right, sorry, before the 2nd of April. All right, thank you. All right, so basically the company is still going to proceed with a pre-pack arrangement. What we call pre-package arrangement is basically to proceed with a scheme arrangement without calling for a formal meeting. But I can see from your questions that there is some confusion about what is happening. And I think that is something that has to be addressed by the company. And I'm also particularly concerned that there doesn't seem to be proper translation. All right. So, Mr. Tang, how would you respond to these questions?
Thank you, Your Honor, if I may. I am aware that there was a document sent out on or around 16 December. It's called what Zipmex Company Limited, Zipmex Thailand, characterized as a private agreement scheme of arrangement, right? As Your Honor had noted at the 2nd December hearing, we informed the court of various ways that we will be taking to address the fact that there are 70,000 possible customer creditors, and we wanted to reduce that number. This is one of the ways that we have tried to do it. I do recall and I do believe seeing that the settlement agreement was translated into the Thai language. I also do recall that the email that went out was sent, I believe, in the Thai language as well. I appreciate the feedback from customers that it may not be entirely clear. And what I can say, with the benefit of my client's backing, is that we are working to provide clarity and to address these concerns, both with the Thai SEC as well as the customers, when it comes to the provision of more easily digestible details and responding to the customers' queries. The queries that have been set out in the webinar chat, Your Honor, are not the first time that I have seen these queries. Right. So we are working together with our client in Thailand as well as Thai counsel to we have taken this on board. We are working together with Thai counsel and Zipmex Thailand to find a means by which we can more easily satisfy the customers or address the customers' concerns. That's actually all I can say at this point,
All right.
Your Honor. Yes.
Do you actually have a 28th December deadline?
I do not know for sure.
All right. Okay. What I would say is that, Mr. Tang, I think you have to advise your clients. I think given these concerns that have been raised in the webinar chat today, as well as what you yourself have candidly indicated about what is happening, I think it would be advisable to make sure that there is enough time taken to address these concerns and to engage constructively with the Thai account holders. All right, so there may have to be some reconsideration of the deadlines. All right.
Yes, Your Honor. Your Honor, if I may just add one or two things, Your Honor. Regarding the 28th December deadline, I can see why this was imposed. As Your Honor was informed at the 2nd December hearing, we had indicated that we intended to send out or dispatch the scheme by 30th December. So I believe that's why 28 was indicated, because this will allow us 2 days to compile responses and then to curate the list such that the scheme document is not sent to people who had already indicated their acceptance of the waiver. But
I think
nonetheless,
you have to take it back. I think given the concerns raised, you may have to revise it. Yeah.
yes, Your Honor. Well noted, and we'd like to, if Your Honor would allow me to, we'd like to address the customers and to reassure them that, you know, your questions have been noted both in this forum and by Zipmex Company Limited and the Zipmex Group in general, and we'll be taking steps to ensure that your concerns are addressed.
All right, thank you. All right, so we have a question as well from, I believe, Mr. Nawita Direkput. Can we promote him, please, Annie?
Yes, I invited him into the room.
Yes, hello.
Yes, Mr. Direkput, yes.
Your Honor, I would like to bring two very grave concerns to the court today.
All right. Mhm.
The first one would be the settlement agreement that was sent out on the 16th of December.
Mm,
And yes, those who have written the complaints in your chat, you've read, the deadline is by 28th of December.
mm,
The settlement agreement in English is very straightforward. But the settlement agreement that was translated into Thai is totally unfair and biased.
mm,
The Securities Exchange Commission of Thailand has criticized the languages used in the Thai settlement agreement, and this has been publicized in the news 2 days ago. For the Thai agreement, it was not translated directly from the English agreement.
mhm,
It requires the client customers to surrender their rights and privileges to take any legal actions against Zipmex in prior to any cryptocurrencies being transferred back to their account.
mm.
And that has been a very major concern to all the clients here in Thailand.
All right,
So,
Yes, thank you for raising that, Mr. Derek Wood. You have copies of these?
yes, I do.
No, no, I
And
I just need the Thai copies at this point. I don't need you to translate it for me. What I will do is I'll ask if you could stay on, and after we conclude, if I could ask you to have a word with my manager, and if you could send a copy of these documents in Thai, that's fine, to my manager. And we will of course forward a copy to the applicant subsequently, but if you could send me a copy of what you have. Do you have a copy of the criticism by the Securities Exchange Commission of Thailand?
yes, I do, Your Honor. It's on every major newspaper in Thailand.
All right. If you could compile that, if I could trouble you to compile that and pass it on to my manager, and I will take it into account. Don't worry if it's in Thai, we'll make arrangements at our end.
Thank you very much, Your Honor. Thank
All
you
right.
for helping us out.
All right. Anything else, Mr. Derek?
On the English arrangement, it's straightforward, except for only one line, Your Honor. To be honest with you, all the clients here in Thailand, we're here in good faith, and we're rather optimistic with this new credible investor. We look forward to having it go through and for everything to work out perfectly. We're willing to surrender our rights and privileges for any legal actions upon a release of all the cryptos back into your account. I believe that's what we're trying to say, upon the release.
Upon release.
So, very well, Your Honor.
All right. Thank you so much, Mr. Derek.
Thank you, sir.
All right. So, Mr. Tang, I think Mr. Derek has also crystallized what has been raised previously in the by the other account holders in the chat. So I think that might be something you might wish to address. These are matters which the court will have to take into account at the approval stage, even for the pre-pack. And I think there might be some things that need to be looked at. But as I indicated, I cannot bless or otherwise, I cannot either approve or disapprove of these things at this time. Unfortunately, and this is for everyone's attention, I can only determine the issue when the pre-pack arrangements are put up to me for approval, which should be before April 2023. But at this point, I will raise my concerns to the company about what has been raised but in the chat, as well as by Mr. Derek Wood, in terms of the language of the Thai documents and the need for engagement with the various account holders. All right, Mr. Tang?
Yes, Your Honor, well noted, and we thank the customer for raising his concerns as well.
All right. What will happen then is that once we get Mr. Derek Wood's bundle of documents, we will forward to Appellant's Counsel, and I will see whether we can get our own translation, but I'd be grateful if the Appellant's Counsel could look into this and let me have your translation as well. All right?
Certainly, Your Honor.
All right, anyone else wishes to raise anything else? So basically, I do note the concerns raised and I want the company to try to engage and to address them. At this point, I cannot say I can stop, well, I can't stop the pre-pack arrangements, but these will be matters that will be taken into account when the pre-pack is brought up later on. So if they are not if they're not resolved, the customers, the account holders, all of you can raise it to me at the hearing at that point, although it might be a bit late in the day. So I hope the company will take steps to address them right now. All right. Any other comments from anyone? Any other concerns? If not, all right. Hold on a moment, please. All right. All right, bring me to the order for today. So I'm turning back to the order for the super priority financing. So in
Yes,
the circumstances, I am minded to grant the super priority. I am satisfied that the requirements under our law for super priority to be given to the investment have been met. And accordingly, I will grant, using the draft amended summons in the annex, I'll grant order in terms of prayers 1A, B, and C. Since they are alternatives, basically. Given that I granted B and C, do you still need 2 and 3, Mr. Tang?
No, Your Honor, there's no necessity for
All
2
right,
and
so
3.
no order as to prayers 2 and 3. Prayer 4 is granted. All right, so basically for everyone's attention, I have granted the super priority that has been sought by the company for the benefit of the investor, so the monies can flow in and the investor get some assurance that it will be secured for the sum or be able to step ahead of everyone else if there's liquidation. And this is necessary so that the company can continue to function basically in the meantime. All right.
Your Honor, if I can just make one clarification.
Yes.
In terms of prayer 1B and 1C, Your Honor,
Yes.
I do believe that we have pleaded it as
Alternatively.
1B or alternatively 1C.
B, yes. So would you rather have B?
Yes, Your Honor.
All right, so I'll grant 1A and 1B then. All right. And no order is to 1C as well as praise 2 and 3. All right then. All right. Can I ask the company to update the court by way of letter about the current engagement?
Yes, Your Honor.
And the issues raised by the matters raised in the chat, as well as by Mr. Derek Wood. We will forward to you a copy of the webinar chat after today. All right. So there's no. So if you're meeting over the next week or two, can I ask for an update by early January, say, by the 6th of January? If things have not been carried out or there have been other complications, just indicate that and that discussions are still ongoing.
Yes, Your Honor.
And
Certainly.
I'll give further directions if need be. All right, so once again, to emphasize, while I'm not able to deal with it today, it is a concern to me to make sure that these pre-pack arrangements are done properly, and some of the concerns raised by the account holders who have put the issues up in the webinar chat, as well as by Mr. Derek Wood, I think have to be addressed. And if they're not, I think they may factor into my deliberations as to the approval for the grant of the scheme of arrangement subsequently. So if things are still not resolved, I will, of course, give the opportunity to the account holders to make known their unhappiness or their concerns about the entire pre-pack scheme of arrangement at the appropriate hearing later on. All right.
Yes, Your Honor.
All right. Thank you. All right. If there's nothing further from anyone. All right. Thank you. And I hope everything will be resolved in the next couple of weeks and that the engagement will continue. Thank you all.
Thank you for indulging us during court vacation, Your Honor.
All right. Thank you.
Grateful for the court's time. Good day.
All right. Good day. Court is adjourned.